So I will try to represent academia here, but also a practical perspective, because I think we look at an area that is very multifaceted, where you have to know EU law, where you have to know practical perspectives, where you have to know national law, and of course national law of different member states to understand the system. And I was especially asked to talk about responsibility sharing and freedom of movement on critical aspects on the Dublin proposals. And I might start with the first critical aspect, that's the language aspect. I do not understand the concept of secondary movements in the language. If you are a Syrian and you move to Turkey, this is a primary movement. Then you move to Greece. This is also a primary movement. Then you move to Macedonia, but if you don't move on, it's not a secondary movement. But if you move on to Hungary or to Croatia via Serbia, you have a secondary movement. So the whole idea of a secondary movement is if you're fleeing to be with your family because you're at risk in Syria and you flee to Sweden, I don't see where a secondary movement comes from. And so the whole concept is also not enshrined in the Schengen area. If you look at what the Schengen area basically provides, then you have internal borders that are not controlled. So the movement is inherent in the Schengen system. I have also some critical aspects, of course, on the use of the word refugee crisis, because, well, the refugees are not the problem. The refugees are the ones suffering from the measures that are coming with the legal measures that are coming with, like the management of the crisis. So I would call it a refugee protection crisis or a migration management crisis, but a refugee crisis is a very difficult wording for me. And it is coupled with some kind of war language that we use. We use frontline member states. We use some kind of collateral damage. And frontline member states is even wrong as well, because if you look at 2015, 3 out of 5 of the member states that had received most of the asylum seekers, namely Sweden, Germany, and Austria, would not qualify as frontline member states in what we're talking about, frontline member states. So I also try to avoid, of course, this language, which is not easy because it's the commonly used language. What I will also do, I will spare to focus on the positive things of the proposals, because this is not my role. I was invited here after the Commission, after EASA, after UNHCR, to give some critics on the proposals. So, of course, there are things that are good in the proposals. I do not deny that, but this is not the role that I was given here as the last speaker. And of course, my role is to be more audacious than the 4th group of member states that Henrik Nielsen was looking at, so going even beyond just a fair sharing of responsibility. This is like an introduction, but I will skip the other introduction because, of course, we heard about all this. I just remind you very shortly about the aims of the Common European Asylum System that have been concluded in 1999 at the Tampere Summit. That was the full and inclusive application of the Geneva Refugee Convention, common minimum standards, and an adequate status for all persons in need of protection. And the goal was a common asylum procedures and a uniform status. We are far from that. I will come back to that. In the sense of solidarity, and it was coupled with a system for the identification of asylum seekers. So that is, the last point is what we really have. We have a system for the identification of asylum seekers, and I will come back to that. And just one thing on language from my side as well. I would call the events of 2016, the package that was proposed, the package coming out of a panic phase. The EU Commission was under an immense pressure to present proposals that are more apt to please member states than the proposals that had been just be transformed in 2015, concluded in 2013. So we had a system that was newly running from 2015, Eurodac was just in place. The Reception Conditions Directive had, the transposition phase had elapsed at that point in time. The same for the Asylum Procedures Directive. So we had a system that was not even tested, but we knew it was failing. And it was failing before, so 2015 showed that it was not well designed. But what I mean by panic is what you see here in bold, is the divergences between the member states in granting protection should be the primary driver of secondary movements. And if you look at what academia has produced, this is just not true. The primary drivers for secondary movements are culture, our family, our language ties. So most of the asylum seekers arriving in Europe do not go to the state where they think they have the best chances for protection, but they have completely other motivations for their movements. So I think the whole system has a problem that it looks at it from an inherent internal logic that we also heard from the Commission this morning, that the divergences lead to a race to the bottom. Yes, that's true. But still asylum seekers decide to go to Germany despite all the legal restrictions that have been introduced there. And there are other systems that would be far better if you assess it from just a very rational point of view of who is granted protection and what reception conditions are there. I don't think that these are the drivers. But this analysis has led to a Dublin IV proposal that has the 4 key elements that Henrik Nielsen has also mentioned. It's stable responsibility. It's a pre-procedure. You have to look at the person before you have an allocation. You have reduced human rights protection, especially for children, for families, and with regard to legal remedies. And you have this corrective allocation mechanism, and I will talk about all these during my presentation. So I talk about the pre-procedure. It is clear that in the negotiations, this pre-procedure might not come as it was proposed in 2016. Still, the pre-procedure was already possible under Dublin III. You could have sent persons back to safe third countries and safe countries of origin, but it was not used because it was not practical. The only member state that made real use of this procedure was Hungary, with regard to persons sending them to Serbia, and their human rights concerns were very clear. So this admissibility procedure contains the safe third country assessment, a first country of asylum assessment. So you already have a big administrative burden on the first member state that has to conduct the procedure. And you have in the procedures regulation an obligatory use of accelerated procedures for if the person is from a safe country of origin or if the person is a danger to the national security or public order. And how do you want to find out whether the person is a danger to national security or public order if you do not do an individual assessment? So everything that comes with the pre-procedure is administrative and very difficult. And looking at safe countries of origin, the question depends very much whether this is effective on the question, what countries are on the list? Because if Turkey stays on the list, and it's proposed to be on the list, then you have a country that in 2014 had a 23% protection rate all over the European states, and that would be then the responsibility of the member state where the persons arrive. And if you look at Turkey, it's probably Greece if the system functions. So you have a problem here, and you will create with the pre-procedure the stable responsibility of the first member state where the persons arrive. So this gives rise to incentives for member state not to register. Because if the person is registered, you are the member state that is responsible if the Dublin IV procedure comes like it is foreseen. In order not to place too much burden on the member states with registration, in the Dublin IV proposal, there is an obligation for the asylum seekers to make their asylum application in the first member state of first entry, and they have to submit all the elements and informations relevant for the determining member states to do the Dublin procedure. So the presumption is that all asylum seekers that arrive in Europe are legal experts. They know what are the relevant elements and what is the information that is relevant to determine responsibility. I think this burden is very high, and it looks at the persons that are there that are trying to abuse the system. But if you look at all reports you have on persons in hotspots, you know that the biggest problem is a lack of information. People just don't know what the system is about, and if they know, they will not have the information from the member states, but from their community, from smugglers. So the question is, how could you actually present information so that persons actually really do know what they have to do? And the sanctions, of course, have consequences. You might be stripped of reception conditions, of your right to receive support under the Reception Conditions Directive. You are then, by European law, as an asylum seeker who is not in the state where he should be, only entitled to emergency health care. And this will move the legal burden to the countries where the person stays. For example, in Germany and also in Switzerland, where I've worked for the last 8 years, there is in the Constitution an article that says every person on the territory has the right to some reception conditions that are kind of as high as the Reception Conditions Directive, and you cannot get rid of the constitutional obligation to provide for these reception conditions. So the efficiency of this legal provision under European asylum law depends on whether member states are actually happy to change their constitutions and to change their concept of dignity. And I don't think that this will happen in especially member states that have a strong constitutional safeguard for every person that is on the territory. The same obligations and sanctions mechanism you'll find in the asylum procedures regulation. There the sanctions are mainly on the use of mandatory use of accelerated procedures and the mandatory use of abandoned procedures. So if the person leaves, you can do that, what the Commission in 2 reports has said you can't do. You tell the person that she has withdrawn implicitly the asylum application and you don't do an assessment on the merits. And this mainly will prevent that persons have access to protection if they move on. And this movement, the problematic with the movement will also be extended to beneficiaries of international protection. So if you move on and if you don't stay in the member state that granted you protection, as a refugee you will be stripped of the possibility to be granted freedom of movement in the European Union after 5 years, because if you move on, the 5 years will count again from zero, from the point when you return to the country that has granted protection. And I think the UNHCR proposal that was presented to say freedom of movement after half a year if the person is self-reliant is a step in the right direction. But the problem is if you are in a member state with a high unemployment rate, you will never be self-reliant and then you can't move on. So the problem still stays that the divergencies, especially in the economic situation of the member states, will have an important impact on the possibility to integrate, to be self-reliant, and to have a durable solution as a refugee if you are granted protection. The sanctions are, I admit it, not as severe as it seems to be, because refugees still have the Schengen right to freedom of movement. So you can move 90 days in a 180 days period, as long as you don't apply for asylum or for a residence permit in another country. To actually make the system work, the purpose of Eurodac has to be changed, and it is proposed to change. So there are 3 sets of data, and at the moment, data of persons, the 3rd set, data of persons illegally present on the territory, is not stored in Eurodac. But now, this data should also be stored in order to have a real idea who does a secondary movement, and this data will be stored for 5 years. And there are also some other new features, as the use of force or detention for fingerprinting purposes, the use of facial images, and the fingerprinting of children as of the age of 6. At the moment, the mandatory age for fingerprinting is 14 in the Eurodac regulation, and the full aim is described already in the title of the new Eurodac regulation. It is to identify an illegal staying third country national or stateless persons, and on requests for the comparison with Eurodac data by member states, law enforcement authorities, and Europol for law enforcement purposes. So the whole idea is that law enforcement authorities and Europol will have full access to Eurodac, and also there's a mandatory look at the Europol database by the migration authorities. So you will have a lot of data protection problems. The European Data Protection Supervisor, I will not go into this very deep, but in his opinion, he basically said, this is a complete annulment of all data protection principles that are there, because you have no data protection if you enter illegally into the territory of the European Union, or if you apply for asylum. And for me, it's very clear that this is most likely that this is the entry point for data protection also for citizens of the European Union. It's not only, at the moment, it's only for asylum seekers and beneficiaries of international protection, but this is not where security logic will stop the proposals. There are some further human rights concerns, and I fail to see how, with the new CJEU judgments on non-refoulement, on effective remedies, on family life, and the old ones on the rights of children, how the proposal is in any way coherent with that. So we have a problem here as well, especially with the non-refoulement. The proposal says only systemic deficiencies. If you look at the CJEU judgment and CK and others, it's clear that also intra-EU, the non-refoulement principle has to be safeguarded, also on an individual basis. Very shortly on the distribution key, I do not share the idea that a distribution key is a good thing, because it is far too administrative. It will create the same problem that was created with relocation now. Security checks are mandatory, there is some matching that has to be done, and it's looking at transfers, at a lot of transfers, and these transfers have not been executed in the Dublin system over the last 13 years. Why should transfers now really work on a large scale, and how should they work? I don't think that transferring is really a possibility. So the potential effects are basically not effective, they're not efficient, and the fairness between member states is coupled with an inherent unfairness towards asylum seekers, because we had talked about the diverging standards. So this will create a problem, and this problem should be solved by border controls. These border controls have been by the CJEU condemned, but we're still moving to border controls. So the question is how these internal border controls in the EU would impact the Schengen area. And there we are back to what Henrik Nielsen said. Is there a link between Schengen and Dublin. And I believe there is a strong link between Schengen and Dublin, because the whole idea of the new proposal is to deter mobility and especially to deter secondary movements. And this is against the idea of Schengen, of free movement, that I presented in the beginning. My conclusions are quite clear. The potential effects of the proposals are that they will enhance and endure internal border controls and therefore endanger the Schengen system as a whole. Visible borders may rise or stay as they are at the moment. Again, and the proposal defines a discriminatory social minimum that will probably also affect other groups of persons. Nationals that need social aid will have the same problem, and it corrupts data protection standards, and this will not only affect the migration area. And as Minos has already showed me that I'm over my time, I will just shortly say I'm not only negative, I have also some keys to solutions. The first would be getting rid of the myth that you have a common system. The fiction of common standards in administration is the thing that hinders effective administration of the common European asylum system. There is a fiction of mutual trust and a fiction of the will to cooperate. And I was very happy to hear Henrik Nielsen to say, well, okay, we know that member states are not cooperating as they should. And I think one should get rid of the idea that more controls on asylum seekers will save Schengen. I don't think that this will happen. What you need to do is to decide whether you want a common European asylum system, and then it has to be really common, or you move back to national asylum systems. Whatever you do, you have to have solutions for opt-out states like Denmark, Ireland, and for associated states like Switzerland, Liechtenstein, Norway, and Iceland. And if you don't have that, and I don't think there is free choice or fair distribution by a key, you have to have adapted solutions for individuals. You have to talk to the people once they arrive, first and individually. That's the point. And then you can do fair and efficient RSD, and you need a real role for the new EU Asylum Agency. And for me, the key to a good asylum system would be freedom of movement after refugee status determination, because then you're moving to a common space for asylum. And that would actually help a lot of people, not only the asylum seekers, but also the administrations, because then it's clear that it's not an asylum policy, but inherent and ingrained in a migration policy. So thank you very much for your attention, and I'm happy happily waiting for the questions that are coming there, I'm sure. Thank you.